My guests are seated. Let me introduce them with one to join us later, and then we will get into the discussion for today. Your views and comments, as always, are welcome through the various platforms that we make available to you, including our Facebook page and 1422. That is the text line. I guess this morning, Kofi Bento. He's a lawyer and he's a vice president of Imani Africa. Kofi, thank you for joining us.
Thank you for having me.
Right. He has, obviously, iconoclastic views of the matters that come up. And he has very easy ways of pointing to what should be the solution.
Yeah.
Also, in the studio, it's a good friend, Yao Pong. He's also a lawyer and teaches at the Central University here in Ghana. And I say, no matter what the issue is, Yao will find the legal point and make it clear to you whether you are breaching or you are not breaching. And
Thank you.
Kweku Kwating, he's now Deputy Minister of Finance of the Republic of Ghana. And Kofi Benton says he's a former brother. and when he says he's a former brother, what he means actually is that, Kweku Kwating, very known. He's been in the forefront of fighting as far as advocacy is concerned for the right things to be done in this country. Now that he's deputy minister, will he continue that? He took many of his fights to the courts and was victorious on a good number of the occasions. Kweku, good morning and welcome to Newsfile.
Thank you.
Good. And we'll be joined shortly by Inu Safuseni, who is MP. He's also a lawyer and MP at Tamale Central and ranking member of Legal and Constitutional Committees of Parliament. Of course, Kweku Kwating is MP for Obuasi West. Now, gentlemen, we will go to Kenya first. And in Kenya, let's hear what the Supreme Court, four of the judges had to say as against two of the judges. It was a panel of 6. And 4 ruled that there were irregularities in the elections of 8th August, and also that the elections were not conducted in accordance with the Constitution of Kenya. So we heard from the Kenyan Supreme Court, also from Raila Odinga, the opposition leader, and also from Uhuru Kenyatta, who is the president and president-elect, now having lost that position, waiting to go through the drama again in 59 days from today. And we have on the phone lines, first of all, James Orengo, who is a lawyer, one of the lawyers for Raila Odinga, who belongs to the NASA opposition group. That's the opposition that came together to form the group NASA. And as you know, Raila Odinga was one of the petitioners, right? Good morning, James, and thank you for joining us here in Accra on Newsfile on Joy FM.
Morning.
Great. How is the morning in Kenya, in Nairobi?
Well, it's not bright, but I think the feeling of happiness cuts across the entire country. A lot of Kenyans are happy with the verdict. Of course, there are those who are not very happy. But it was a historic moment for every Kenyan because this decision is a historic setting precedent.
Right. It's historic and precedent not only for Kenya but for Africa, because it's being hailed all across the continent, because you live in a continent where judges are thought not to be that bold to say to a president that you are wrong. But what are the prospects of the consequences of this decision on Kenya?
I think the consequences are great. First, The judiciary has been on trial for many years in Kenya. And part of our campaign for a new constitution was based on concerns of Kenyans who felt over the years that the judiciary was more executive than the executive. So we had a new constitutional dispensation that gave the judicial authority to the court in very firm words. And ever since the year 2010, when the constitution was promulgated, Kenyans generally were still not quite confident that we had made progress insofar as the judiciary asserting its judicial authority.
Right. This is the second time.
The apex court has made a decision, and this decision is going to embolden the rest of the judiciary.
Right. I think we'll get back to a bit of the consequence, including the cost involved and the time limited for you to go back to the elections, how Kenya is going to be able to deal with that. But this is the second time you have had to go to the court. After the first time where you lost, you were so unhappy and gave indications that the court was not where to prosecute an election.
Yes, we had said we were not going to the courts again, but certain elements within civil society in Kenya had said they were going to go to court, and we encouraged that. But, the state assaulted the premises of these civil society groups, and they were not able to put a case together, marshal resources. So then we said in the circumstances, despite our determination not to go to court in the beginning, we said, okay, we'll give the Supreme Court a chance, particularly because it had been reconstituted. Part of the membership of that court, which was there in 2013, had either retired or by, the operation of the law left the court.
What would you say to those who say that you went to this court on a purely technical, procedural, aspect of the elections, and you have won on that basis, but not on the substance, as regards the facts of the votes counted and the margin of victory against the NASA group?
The case all along was on the substance. There are constitutional principles which the electoral body has to comply with. There's the electoral law which they have to comply with. Those are matters of substance, because no election can be held in a fair and free manner unless those principles and statutory provisions are abided with. But having said that, there is evidence before the court that showed that the president-elect was getting votes which were not genuine votes. There was an algorithm, or if you will, a way of enhancing of the president-elect during the transmission. The votes were counted probably at the polling stations, but when these votes were now the results being transmitted to the National Tallying Center, they were adding up or enhancing that vote by a certain percentage, which was constant. And I think we convinced the public and the court that in fact was true.
Okay.
In fact, one of the big moments in the court was when an advocate for the president was asked the question, and the advocate for the Electoral Commission, that whenever a voter went to the station and was given 6 ballots for various positions for the elections, if that voter just voted the president, what happened to the rest of the votes? This question was
the rest of the ballot papers, the rest of the 5 ballot papers.
Ballot papers. This question was pertinent because the turnout for the other elections were about 1 million or so lower than the votes cast in the presidential elections. And this raised a lot of questions, how somebody can go to a polling station, vote for the president, and not vote for the senator or member of the National Assembly or for the governor. By all practical reasons, reasons and all possibilities, there was no way that that could happen.
Was it not your expectation centrally and prayer that on the basis of your allegations, a recount would have been what ought to be the verdict, a recount?
The real count could have been the verdict, and we were prepared for that. You know, the presidential election petitions have to take place after filing within 14 days. To mobilize and make sure that all the ballot papers are brought into the National Tallying Center and brought into court. It is an exercise which requires a lot more time. But if things were done properly at the polling station, and in Kenya, the presidential elections are held at the constituencies. There are only about 290. If a recount were to be done in the 290 constituencies, I can tell you, and I'm sure that the verdict would have been that the president-elect did not get the 8 million odd votes he was claimed to have garnered during the elections.
When the court said that the third respondent did nothing wrong, what did you understand that to mean?
Well, you know, there were several grounds upon which this election petition was being prosecuted. And one, you know, and this involved basically the way the Electoral Commission conducted the election. In fact, 80% of our complaints before the court was in relation to the Electoral Commission and its chairman. There were complaints against the president, Uhuru Kenyatta.
Who was the third respondent?
Yeah, he was the third respondent, that he used state resources. A matter which is, you know, evident, you know, throughout the campaign. He was using cabinet secretaries who are state officers who are not required to take, you know, or participate or take part in elections on behalf of any political party or any candidate. He was using, you know, government resources to give goodies to, you know, the electorate, you know, promising to give certain things to the electorate.
Very typical of an African incumbency, right? Incumbency abuse, very typical. It's all over the place.
No. During elections, he cannot do that. He cannot go around during the elections and offer inducements. I mean, those are electoral misconduct. They're in the law, what he can do and what he can do.
Yes, but the court said that it could not find evidence of misconduct on the part of Uhuru Kenyatta. That's the question I'm asking. These allegations that you harped on so much, the court said it could not find any evidence of misconduct against him.
Yes, that was a finding of the court, but we think we had sufficient evidence. And I can tell you this is not the end of the matter, because there is the Office of the Director of Public Prosecutions, where we can still follow these complaints. We can also mount private prosecution in regard to these allegations. And to that extent, you know, the story is not yet over.
Okay. Okay, don't start your debate here so you confuse my guest on the phone lines. Okay. Now, part of the question that is being raised by one of my panelists on the show this morning, a lawyer of substantial years at the bar in Ghana and also a former minister, is that this is a Supreme Court decision that says it found nothing wrong, no misconduct against the president, Uhuru Kenyatta. You are saying that these are matters that you can take on later for prosecution. How do you do that? Because this is a Supreme Court decision.
No. There is a decision of the of this same Supreme Court in which I participated, where they said, you know, the prosecution of electoral offences. We've got an Election Offences Act.
Right.
It is only in the criminal courts that those prosecutions can be sued in the context of the criminal law. there is the context of corruption and misconduct within the context of the electoral law.
Yeah, it's a small point, but it's a small point, but what the three lawyers in the studio this morning are telling me suggests that what you are going to do is going to be a very difficult one, because the Supreme Court has pronounced that no misconduct, there's no wrongdoing against, the president. So that will be their defense when you go to prosecute. How are you going to be able to scale that?
No. That not bar, at an appropriate time, somebody taking up criminal prosecution. That's a finding of a court which is sitting as an election court. The Supreme Court sits as an election court.
Okay.
That does not bar the Director of Public Prosecution.
That's a great clarification there. Right. That's a great clarification there.
Yes.
Yes. So, but what do you say about the dissenting opinions that were rendered? They suggest that you presented practically no evidence to back your claims of irregularities, and therefore the majority was completely wrong in what they held.
Well, the minority in the court had their say, but the majority's decision in this circumstance is the one that counts.
Right.
But the two judges who had a minority decision or opinion, right along, from their standing and jurisprudence, is something that every Kenyan expected from them. It's just like in the American Supreme Court. There are judges who are conservative. You can more or less determine where they lean on any matter. So as far as these two judges are concerned, it was not a shocker to the Kenyan people insofar as the position they took in this matter.
Okay. So when are you supposed to start campaigning again?
Well, President Uhuru, when the matter came out, he made a statement. He addressed a crowd in the city.
Yes. What do you have to say about that? Yeah.
I mean, it was his right to, try and go to his crowd and tell them all is all right. The only terrible thing that happened on account of his speech to the masses on that day, which was yesterday, was to talk about the judges in a very personal way. I mean, it was tantamount to abusing the judges in words which I cannot repeat in this interview.
Right.
And under our Constitution, the President is the one who is expected to defend, protect, and promote the Constitution and make sure that the organs of state are equally protected when they are exercising their mandate under the Constitution. So there were some remarks there which has not been kindly taken by the public as a whole.
Okay. So I'm asking your clients, of course, you are counsel advocating for your clients in court. When are they supposed to start campaigning, and how different will the election process be now that you have challenged the process that has been used?
Well, the campaign, the candidates can start running around the country now. I don't think that they can be stopped from campaigning, but the official period for campaign begins when the Electoral Commission sets out the timetable, when they are required, to send in their applications to the Commission, as it were, or indication that they're going to run for the seat of President. And thereafter, after they are found to qualify to run, which there's nothing to stop them from running in the elections, the two of them, then the Electoral Commission will lay out the election timetable, and other people can come and contest. This is not a rerun. It's a fresh presidential election under our law.
Right.
And any other candidate or the other candidates who participated are free to run. What we are concerned with is, in view of the findings of the court and matters that we think border on criminality, whether or not some of the elements within that commission, particularly the secretariat, and one or two commissioners can actually be allowed to continue to be part of that process leading up to the election.
Okay. So you are going to contest that?
Yeah, we are going to raise it as an important issue that has got to be dealt with.
Effectively, you are going to seek the removal of certain persons within the Electoral Commission.
Yeah, certain persons, particularly the secretariat. There are a lot of people there whose track record, has not been good, going back to not just the last elections, but even the elections held in the year 2007. And there is a commissioner who was in charge of of ICT, who we think was privy to the misconduct that led to these irregularities and other election malpractice.
Okay. Don't you foresee that this is going to drag and the 60 days might not be sufficient?
It's going to drag on, but the price that has to be paid for us to have free and fair elections must be paid. You remember that we had to push forward the amendment of certain electoral, certain provisions of the electoral law before the elections until the early part of this year. We're still going through those amendments.
Okay.
Without that, those amendments, actually, even to be able to prosecute this petition would have been very difficult. But with the new electronic system of elections, especially on the three areas of transmission, voter identification and voter registration. Without that law, it would have been very difficult to find the footprints of the Electoral Commission in the misdeeds that we portrayed to the court.
Yes, I mean for us to conclude the interview at this point, but I would want you to answer this question. Those within the Secretariat that you seek to be removed, is there any one of them that you have any specific evidence against as having tampered or manipulated or rigged the elections?
We have plenty of material that we will put forward to them as a commission, and this is not an idle thought. The chairman of the Electoral Commission himself, in an interview yesterday, said he is going to make certain changes, and he invited the Director of Public Prosecution to investigate investigate the process and those who may have participated in those misdeeds. He will not be inviting the Director of Public Prosecution if there was nothing wrong that had happened. He will be defending the commission to the hilt.
Yes, and finally, the Uhuru Kenyatta's legal team sought to suggest, even after the judgment had been rendered, that what ought to have applied is what you know within the legal parlance as the de minimis rule, that the votes that are being contested are not sufficient to change the circumstances or the results. And therefore, this ruling is such an injustice against the will of the Kenyan people.
No, I can tell you, even on the question of numbers, and we did say at the beginning that we had won this election. It was a stolen election. Our approach to this petition was both qualitative and quantitative. We were out to demonstrate and show that we had garnered more votes than the president-elect.
Okay.
And if those servers would have been opened, and if all the transactions in the server were laid bare, particularly 2 days before the elections and on the day of polling and the 3 days after the elections, if those would have been made available to the public, I can tell you without fear of contradiction that we will not be talking about a new election. We would have been inviting the court to declare Raila Odinga as president.
Right. The presumption now is that Raila Odinga is ready to accept the results of the next elections in 60 days, right?
If it is free and fair. We have always said we are ready to accept if it is free and fair.
Thank you very, very much. James Orengo is lead counsel for Raila Odinga, who is the first petitioner or the petitioners in this presidential election historic in Kenya. We had agreed to speak to the EIB chairperson, Wafula Chibukati, and we are trying to raise him on the phone. Unfortunately, we are not getting through to getting him pick his phone now. When we do, we'll also bring you the other side of the story as far as the Electoral Commission is concerned. But once again, thank you very much indeed, sir. Okay, now let's come to the studio here, and without any specific questioning to you, you have been itching to speak and even do the questioning of James Orengo. Yes. Kofi, what do you say?
Oh, I'm not the one who is itching to speak.
But
my senior
all
here.
of you.
But, you know, it's interesting because it's law.
Right.
And this is deep law.
Right.
You know, it's jurisprudence. We are dealing with the Supreme Court. We are dealing with the highest office of the land. And it resonates with us because we just got out of our 8-month situation. And every lawyer I know has been discussing whether that process we have here is good for our democracy.
Right.
That you need 8 months, the government is running, sometimes it says it's not running well, sometimes it says it's running okay and all those things. And we all clearly think there must be some tweaking to our system. And the one place we keep looking at is Kenya. Because of what has happened there in the past concerning this Supreme Court and how they handle presidential disputes. And now they throw this one also at us.
Yeah.
Okay. They, in record time, they come out, they boldly cancel a very expensive election in a place like Kenya where elections cost lives. So there's so much to think through in terms of politics, in terms of the social engineering it brings, but also in terms of law. I mean, and frankly, I don't think we should go that way. If we go that way, we'll spoil this program. So let's leave the legal stuff out. But I think it's important.
Until this, what they had done earlier was seen as very poor compared to what our Supreme Court did until this.
Until this. And, you know, for those who have been studying, I've been having these discussions with Professor Prempe. And people believe that they've set themselves up, okay, for such great things, even though they were having problems at the time. And now they're showing us what is possible with the kind of structure they've built. And so, leaving the law, I think what we should concern ourselves with, and for me, really, what's important in terms of social engineering, is the structure of that system. We should really take a look at the structure of a system which is able to take a presidential election petition and make a definitive judgment on it, make it clear in this short time. And we ought to learn from the best. I mean, there's a lot to say about what has happened in Kenya, but first, I think most importantly, before we go into any other discussion, is we need to figure out, look, we've tried. Ghana, we do so many things, and we are the first at so many things. But there will be a few things that some people will do better than us. And in this case, Kenya is teaching us the way. We should find a way to go and find out how they got this right and see how we are going to infuse the positive aspects of those things into our own system and see how we can avoid having 8 months of litigation and have this kind of short arrangement so that we can reset our system and go forward. But there's something else also that I think is important to mention. In analyzing the decision and the legal statements that they made, it revealed a weakness in the Kenyan system, which is ironically a strength in ours. And the weakness is this: their polling station system and the recording arrangements there seem to leave something, okay, which leads to this kind of dispute, which we fixed when we tightened up the pink sheet arrangements.
Right.
Okay, and I'm happy to say I was part of that arrangement.
Of course,
yes.
yeah.
And you know,
it was you, Shishi,
led by Sheshe, yes, myself, and Hassan Tampule.
Right.
Yeah, we went in, and the Supreme Court really tightened the polling recording arrangements and make sure that from the polling station you would have exactly what happened there, and it's signed by everybody, and it's done. Now, if you have a problem, there's a way of, recording it there, and then it's very easy if you're going to have a petition. This Kenyan system revealed that they didn't have something as good as what we had. And you saw in our election that Chairman McMinu, even before the EC chairperson declared, was able to definitively say that they won the election because he had those sheets. And if there was going to be a dispute, those sheets would have been the evidence, and there would be no other way of determining that. So that's a strength in our system.
Right.
That being said, disputes can happen. Yeah. And so we need to get back to Kenya and find out what in that structure we can learn so our disputes don't last for 8 months.
You are interested in some of the, you may call them optics, but beyond the optics. They do this, of course, we also had ours, telecast. They do this way, and the same day that the verdict is given, you have it ready, and it's circulating the whole world. Some learnings?
Oh, absolutely. And we've had these discussions here.
Right.
I humbly suggest that there is no reason why a judgment at the time it is being delivered should not be ready to be circulated everywhere and electronically. And again, the Kenyans are showing us that it's done. It's doable. In other places, this is not discussed. We need to make that a rule. And I think it should be part of the judicial system that the wherewithal must be present. You also note that in delivering the judgments, they didn't deliver the full reasoning.
Yes.
Okay, they have time to do that.
That is so.
But they have the abridged sections. And in ours, it was all over the world. We need to learn these things. And frankly, there's no excuse why we can't do it here.
Right.
Like we all know, some judges in this country do it.
Yes, they do.
They do it.
Yeah, they do.
So it must be a rule so that we can all have the benefit of these things.
Okay. And you see, just that last point.
Yeah.
When we were done with our petition, it took some of us, you have to have a privileged opportunity.
That's right.
To get the almost 600-page, judgment ready. So I got it around 9 p.m. and Kofi had to get it, I think, early morning. I read all night before the next morning so that we inform the people and take away some of the misleading things that were going on. That also put the nation at a tipping point. And once again, I say congratulations to him, because within a short time, he was able to break down some of the things that they had ruled, they had said, and all of that. And people got to understand. And you realize that a bit of the tension had to calm down.
Right.
Taking it from where he just ended, what can we learn from just the optics?
Well, yes, and it was one of the things that really struck me, technology, and how we can apply it for development in all respects. And also how it will enable us to apply the best forms of amendment to even our rules of court. I had the benefit to get a book, I will lend it to you, where in England, Lord Wolfe was commending India for accepting a petition which was in the form of a letter. When the public realized that their cases were not being heard early enough or quickly enough, they put together a letter to the Supreme Court and asked them to determine the matter. And the Indian Supreme Court did not dismiss them or throw them away. They determined the matter judicially based on just a letter to them by some civil society groups. And it was a huge thing for even England. And Lord Wolfe commended them and has recommended also to all others to at least shed some of these old technicalities that sometimes lead to cases pending for many years, and some people even lose, some of the parties die, or by the time they get a judgment, it may have been nugatory because there will be so much that have gone off which will not be consistent with the expectation of the person at the time you went to court. So things like this. I mean, there's nothing, people have started. You, a lawyer or a litigant sits in his room, upload or download a writ of summons, you fill it in, you send it to the court files it, the court sends it electronically to the other lawyers or the parties when their addresses are indicated. So the first time you go to court will be where the case is being slated for hearing.
And whilst our Supreme Court has consistently said that, you know, technicalities should not be allowed to defeat substance.
That's right.
They are guilty because often, like what you said, they will not entertain it. They'll throw it away because they'll say, look, what you have brought does not meet the standard. And it is this Supreme Court that in 2014, through Justice Wood, said, described something as a parody of justice, a case that took 40 years to be concluded.
Yes. But you see, the difficulty is also maybe with the lawmakers as well. But of course, when it comes to rules of court, which is at the core of this, it is the judiciary that should generate it in the form of constitutional instrument and send to Parliament.
Right, so now Kenya specific and the outcome.
Yes, now, but just maybe so that you don't forget that I'm used to it.
Right,
I'm
that's
just making a quick reference to the presidential election petition judgment. That's our own.
Right.
A very striking and profound statement was made by one of the learned justices. For starters, I'm quoting, I will state that the judiciary in Ghana, like its counterparts in other jurisdictions, does not readily invalidate a public election, but often strives in the public interest to sustain it. And I find this very, very
And who are you quoting?
striking. I'm quoting from the judgment.
Who are you quoting? Which of the
I'm
judges are
quoting
you
from
quoting?
the judgment, so they can, and all interested parties can find.
Okay, go ahead. You go ahead. Go
I mean,
ahead.
that would be. I hold a position
I will
that
not
I
help
don't
him.
like.
Yeah,
I
yeah.
usually don't like to personalize courts.
But that's not personal.
court is court.
It's a matter of
There's a
fact.
majority decision and there's a minority
I
decision.
don't have a judgment here. I would
It's
have
easy,
told the public.
it's easy to get a copy of this judgment. Read it for yourself. But I'm saying that this is quite profound. Now, so when you get a decision like this, then you have to match it against our own.
But again, that statement by that judge was supported sufficiently
That's right.
with how election petitions are handled across
And
the
that
world.
is how what I'm going to, even
Right.
in our case.
Okay.
If you, under this 1992 dispensation, from J.H. Mensah up to Babajama, Collins Dowda, I think his own is an exception. But the growing evidence is that most
Rebecca
of these,
Adote Ayawaso.
yes, most of these cases are thrown out. They are rather the decision of the AC is affirmed by the court. But interestingly, again, the growing evidence is that in subsequent elections, those who lost in the court win at the elections. And let me give you an example.
Oh, but
Babajama
the
again.
example you gave, the Ayawaso matter, the court did not affirm the decision.
No, that was so much, and I just spoke with Honorable Amo, my good friend.
Yes.
You know that first the High Court dismissed it on technical grounds.
That's right.
That the security for costs was not paid on the day, even though he says he paid it, but he was not given official receipt. That is one. Subsequently, he won an election. Of course, they got that decision
No,
set
but he
aside.
won his case, but unfortunately, by the time he could take over, by the time he won, the tenure for
that
Parliament
that
had
is not the
expired.
final, as we speak. Let's highlight it. Now, so then they went to the same High Court, differently constituted, and got Seshurara to set aside the decision of the first High Court. The state went to the Court of Appeal, and the Court of Appeal affirmed the decision of the first High Court. Then they filed an appeal. I spoke with him this morning. As we speak, the appeal is technically pending before the Supreme Court.
Okay.
So strictly speaking, that case has not ended.
Okay.
But the point I'm making is that it appears that there's more example for the case where when a person had contested presidential or election, public elections, they subsequently contest the election and they win. And I'm giving Honorable Amos one.
Yeah, 2000
For example, Baba Jamal, he lost, and subsequently he went to court, he was thrown out, and then he won the election. President Akufo-Addo's example is it's also likely that this Kenyan one may confirm this trend. So the point is, whilst we insist that when there is a dispute, the best way to go to is the court, and that we have to insist on, people who lose cases in court should not also give up.
Okay.
They should have confidence in the system. Right. And that is why I was worried, even this morning, with the statement that our learned friend made from Kenya, in respect of the two judges who were in the minority.
He's talking about American jurisprudence. What is he wrong to say that you can predict a judge?
Oh yes, I mean in our case, I'm saying that quote and unquote judges are not robots. Judges determine cases not based on their religious affiliation alone.
But he's talking about what is established in our learning, the American jurisprudence. When you are going to the American Supreme Court, you are able to determine who to address and who to ignore.
But not all the time. Not all the time, because the previous one, all the judges threw them out. Some of the judges have now ruled for them.
Okay.
The same presidential elections based on similar facts and the law. So I think there's too much danger in that. And then how can you then also then criticize the president when he also then casts aspersions at the majority of the judges? We should condemn both. We shouldn't see judges as we shouldn't see members of parliament to be persons who will always toe one line and that is it. For me, it's too dangerous.
We should always qualify it. There are bad judges and there are good judges.
Well,
just as there are good politicians and bad politicians.
It also depends on whether you win your case before that judge, before you describe him in such adjectives.
I've lost cases before judges I have so much respect for.
Yeah. Well, but then subsequently, if you appeal, that is why the appeal system is there. Well, if you appeal and go before 3 or 5 or 7 justices,
can we hear?
They overrule the one that.
Can we hear from?
I'm not giving you the ruling.
Yes, Honourable.
Well, thank you very much, Samson. To start with, let me send out Barakadasala to the Muslims in Obuasi and in the country generally. We wish them a good occasion, and we hope that this will bring more blessings from Allah to our country.
And there's one sitting right by you. You have.
Yes.
Have you given him specific?
Yes.
I've done that.
I've done that already privately.
On air.
He's more concerned with his constituency.
Actually, let me do it now. And welcome to the show, Honourable. He's been here for quite a while. I was actually expecting to introduce him and to say Barakada Sallah, as I said.
Good. Samson, for me, what has happened in Kenya, an election happening, and the courts coming to say this election was not properly conducted, I annul it, or we annul it, go back and do it again, is a beginning of an interrogation of a myth that has existed, that in Africa, you go into the election, and once the results are announced, that's it. And politicians, we are very used to that. And people will tell you that, look, just make sure you get the numbers announced in your favor, and that's it. And they cite the cases that you have mentioned as examples. So they say, win the election, whatever it takes. And when they say whatever it takes, it means a lot. Whatever it takes, win.
And thankfully, because of that, the NPP's aim was to win the elections at the polls.
Yes,
because you were not minded to go to court the next time.
In a sense, you're right. But it also comes from a certain position that has been articulated by election management bodies, including our own, that if you are intimidated or if violence happens at the polling station, the Electoral Commission or that elections management body would not have the competence to determine the extent to which that criminal conduct impacted the election. And therefore, they would declare the results as would come to them, and that it is for you, the person that feels aggrieved, to go to the court. And if the court said the environment was not right for a free and fair election, the elections management body is then willing to go along with the court and perhaps reconduct the election. And because you're not sure what will happen in the courts, the thing is that you make sure that you do whatever it takes to get the outcomes at the polling station.
Right.
What we are beginning to see,
including especially calling the election quickly enough.
Exactly, and what we are beginning to see by this, and I hope it's a trend that would continue, is that you don't have to do whatever it takes, even if it's illegitimate, and that there are other avenues for you if things did not go right. And so it is from that angle that I look at this, and I think it is good that our courts should begin to have the confidence to say, never mind the cost, never mind the fear of another election, and with it, the suspicions of violence and all the things that we we have come to be afraid of about elections. Never mind, give people the comfort that if they have genuine grievances, the courts would uphold them. I think this is good. But I have to qualify that quickly and to say, in the case of the Kenyan opposition, they probably are not out of the woods yet. Mm-hmm. You see, if the re-election, that is supposed to happen 60 days from the ruling, if that re-election happens, and somehow the elections management body that produced what they have described as a bad election has not repented, and they go ahead and they do the wrong things, and the opposition loses the election again. The question is that, you think the people of Kenya will be willing to listen to another, oh, it was a bad election, it should be cancelled again? I doubt it. Right. And that is why I think even though it is good signal, and I hope our courts are paying attention, that it is important to give politicians the assurance that if things happen wrong, that you are in a position to correct them for us. But the opposition, I wish them all the best. They go into this election, perhaps even as underdogs. I'm not quite sure that the point you made is exactly correct. That because they've gone to court, whether the court ruled for them or not, that the next time they are likely to win.
No, I said the growing evidence.
When I listen,
there are examples.
Okay, when I listen to
your own president, our president is an example.
Well, in subsequent elections, but not when the election is annulled, and all those structures that made the wrong election possible are probably still alive.
So I think people will be deterred now.
But
I hope so.
You heard James Orengo say, lawyer for Raila Odinga, say that they intend to ensure that some persons within the elections management body are removed.
I hope they succeed. You see, it is not an easy task fighting the ruling government when that government has the Electoral Commission on their side, unless the sense of opposition to the government across the country is so big that sometimes, even though the leadership of the the election management body at the top may have a certain position, their officers on the ground do not feel same because they are part of the general public that says we are sick and tired of this government. If you don't have that, it is a lot of hard work working against the ruling government that has the support of the elections management body. Right. From what I gather, and I conclude on this, from what I gather from the case they sent to court, the petition they sent to court, they think that the election management body is oriented to work for the government. I hope that they are able to neutralize this, if it is the case, so that they may have a different outcome in the re-election. Otherwise, we may well have another election, and if it does not go their way, the best they can say is that the guys have stolen the thing again, but we give it to God. You know, that's what I think.
Okay, so let's hear from Laji News of Seni now. Yeah.
I think basically, and let me also take opportunity to wish all my Muslim brothers and sisters Eid al-Mubarak. And may this year and the coming years bring us good luck, prosperity, and happiness. I think that it will be an understatement to say that the Kenyan election results given by the decision of the Supreme Court is historic. It's an understatement. All over the world, not only in Africa, all over the world, the courts have been very reluctant in annulling elections because of the sheer cost of elections. And that's why even the minimis rule has been held high in many other jurisdictions. In the American situation, yesterday, the New York Times published that probably America has to learn from the bold and courageous decision of the Kenyan people.
They have affinity to
universal adult suffrage.
Yeah,
it has a selection.
Yeah, so no. What I'm saying is that because they had said that.
Can't fix this.
No, what I'm saying is that because the New York Times has said that 21 states in America had evidence of illegalities. 21 states had evidence of Russian influence. 21 states. But again,
The electoral
the
college
states
can choose to overlook all of
the
that.
states did not even investigate those things because they didn't want to rock the boats. But yes, it's a very, very bold decision. Let's also say that what we are all commenting on is a decision of the court and not the reasoned judgment of the court. It's very important.
That's true.
And so because when we finally get the judgment, we will be able to understand exactly
That they gave pointers.
They gave pointers, yes. They gave pointers. They set issues and answered those issues. Was the election conducted in accordance with the principles of the Constitution and the laws of Kenya? That was an issue. They said no.
Same as ours.
Was the election conducted in such a way that they recorded irregularities and illegalities? They said yes. Were the illegalities and irregularities of an extent that they compromised the integrity of the elections? They said yes. So these are the issues that they answered. Okay, so we wait and see what are the illegalities and the irregularities that affected the elections and threw away the de minimis rule.
Okay.
Were they of such a substantial nature in the view of the court that warranted that decision? So I'm sure that in all jurisdictions, analogous jurisdictions, Commonwealth jurisdictions, this decision in Kenya will be stated. At least in Ghana, there are pointers, and I was listening to your take. The speed at which they decided this matter. Also, they decided with alacrity, actually. It's also commendable. I mean, they didn't keep the Kenyans on tenterhooks. They didn't give political parties an opportunity to play propaganda with the decisions of the court. So clearly, we have a lot to learn. And Raleigh Odinga, I mean, you don't write off what the lessons that have clearly emerged from the decision of the Kenyan Supreme Court is that don't write away a court without first seeking, to have them adjudicate on your matter.
Right.
They are human beings. And they determine matters on their merit. And that again goes to buttress the point that probably in their first petition, they lacked merit. The first petition lacked merit. That's why it was thrown away. And so don't do that. Then the electoral boundary commission, I thought that initially...
In respect of the matter of the speed that we are all commending, it's also noteworthy to understand that whilst we look at Ghana, Ghana is capable of doing things like that. In the run-up to the 2016 elections, we saw how the judiciary was very active in ensuring that cases were dispensed with dispatch. And coincidentally, I was involved in one, the Joe Beduan Service, the new patriotic party. There was a Joseph Mensah who was my client. Unfortunately, the MPP was trying to use some ways to kick him out of the race. When we went to court on that matter, the trial took 3 days, and the matter was concluded, and we're victorious. He's a member of Parliament now.
Why I like your take is that you say that we should define the words like expeditiously, quickly, and set timelines. Timelines, we can always hold the courts to the timeline. So yes, we should define how expeditiously by certain timelines. So
and the court also set line for the lawyers. Very important.
Thirdly,
can't go beyond the line.
Before the decision of the court, I thought that the Kenyan Independent Electoral and Boundary Commission did a very good job.
Which is
the called out, even though the election results were declared at the polling stations, they also went ahead to look at the election results polling station by polling station. I thought that was good.
Okay.
I mean, for us, we just compile and declare.
Okay.
Just a quick one.
As I suggested to him very finally, and we move on and come to Ghana and deal with our own problems. And I've been asking, we understand that somewhere in Ethiopia they are building 3 brand new international standard airports, and it's going to cost them $64 million only. Here in Ghana, we are spending in excess of $150 million. SNIT and the local government ministry doing what? Procuring not needed waste bins and malfunctioning IT systems. The question is, for the Kenyan issue, do you think that the better way to resolve it was to have ordered a recount rather than go back and do it all over again? Because it borders on the numbers.
No, what did they ask for? What did the lawyers ask for?
He said they were expecting that.
They asked for a declaration that the elections were not conducted in accordance with the constitution they were given.
Exactly.
They asked for a declaration that the irregularities and illegalities were said that they affected the integrity of the election.
The court was not bound.
Yes, yes. But the court said, yes, we agree. We have, judging from the affidavit evidence you have presented, we think that you are right.
But you see, that detail is important because you see, if they had the kind of pink sheet regime we have now,
yes,
they could have gone to a recount, saved themselves another election. Yes. That reveals the strength in ours and the weakness in theirs.
He says the 14 days is not enough. We gave to KPMG to do some of the, you know, auditing for us.
I think they learned from our election petition.
Yes, surely.
Our judges have been there, our chief justice has been
we
there.
go back and forth.
And of course, H.K.C. Prempe, we say Kenya man. He's always there.
Sure.
And we'll be learning back and forth. So maybe now they will realize that it's good to have a pink sheet recording arrangement so that in case of situations like this, you can go back and just do a recount or whatever it is.
Right.
Let me say quickly on this speed thing you're talking about. Look, it is possible in our courts. In our case led by
Akutuampa.
Instead of the
Forgive us, we keep saying shishi, but that's
instead of the Supreme Court justices adjourning the matter and coming back for the final ruling and in the consequential orders, they ordered us, all counsel, to go into a room. We spent 3 hours there. We fixed the issue. We came back to court. They reconvened and they adopted them.
great.
Yeah, sure. That's what I'm saying.
It's doable.
I mean, it's doable. It's
Yeah.
doable.
You seem to say I truncated your very final point, but do that
We're just
quickly
going
and
to
let's go.
commend the parties. I mean, comment. I mean, you can't take away celebration from victorious parties. I mean, so when I was listening to the lawyer, I could see, I mean, some celebration in the way he was presenting the outcome of the election results in Kenya, in particular the Supreme Court decision.
Okay.
So let's also commend the president. Actually, it's good.
Commend him for those insightful comments that he's had to make in some of his constituencies, calling the judges tax.
No, the judges have been called tax before, even in Ghana.
But you don't commend somebody who repeats that.
No.
And say
But
that
he says that
president.
this issue is about Kenya. It's about peace.
That's the
He
first
accepts
statement,
he accepts the results, even though he disagrees with it.
He went campaigning
It's very
at the Chief
important
Justice's,
here. But
the Chief Justice's
justices are human
home
beings.
constituency. He went campaigning and telling the people that, you know, we have made your son a Chief Justice, so vote for us.
Well, but we will not do that.
And interestingly, the same person who led the
And then finally, the people of Kenya. Finally, the people of Kenya. I think that they've risen to the occasion and that we need to commend them.
Let's hope
At
and
least
pray.
they've shown to the
Let's hope and pray that they don't get to the bloodbath in 2007 and the aftermath of 2013, where, you know, hundreds, you know, were killed just because of elections.
Sure.
We're taking a break here, and when we return, we have more of the issues that concern us locally here in Ghana to deal with. We'll be right back.